What happens when a patient is unconscious, the situation is non-emergency and consent is taken from a relative instead of the patient? Can that consent legally protect the doctor? The Supreme Court answered this clearly in Samira Kohli versus Dr. Prabha Manchanda. A 44-year-old unmarried woman consulted a doctor for prolonged menstrual bleeding for 9 days. After USG scan, laparoscopy was advised under anesthesia to make an affirmative diagnosis. Next day, the patient went to the doctor along with her mother. Admission card indicated admission for diagnostic and operative laparoscopy. Consent form indicated the procedure as diagnostic and operative laparoscopy. Laparotomy may be needed. Laparoscopy was started under anesthesia. When the patient was still unconscious, an assistant doctor came out of the operation theatre and obtained consent of patient's mother for performing hysterectomy. Thereafter, the doctor performed abdominal hysterectomy and bilateral salpingo-oophorectomy. After 5 days, the patient left the clinic without settling the bill. The doctor filed a police complaint alleging that patient's friend had abused and threatened her and that the patient did not pay her bill. A legal notice was sent to the patient demanding Rs 39,325 for professional services. The patient also filed a complaint against the doctor alleging negligence and unauthorized removal of her reproductive organs, claiming a compensation of Rs 25 lakhs before the National Consumer Dispute Redressal Commission. On dismissal of the complaint by the National Commission, the matter reached the Supreme Court. The Honorable Supreme Court held that in medical law, where a surgeon is consulted by a patient and consent of the patient is taken for a diagnostic procedure or surgery, such consent cannot be considered as an authorization or permission to perform therapeutic surgery, either conservative or radical. Similarly, when the consent by the patient is for a particular operative surgery, it cannot be treated as a consent for an unauthorized additional procedure involving removal of an organ only on the ground that such removal is beneficial to the patient or is likely to prevent some damage from developing in the future. The only exception to this rule is where the additional procedure, though unauthorized, is necessary in order to save the life or preserve the health of the patient, and it would be unreasonable to delay such unauthorized procedure until patient regains consciousness and takes a decision. In this case, consent by mother cannot be treated as valid or real consent. There was no consent by the patient for performing hysterectomy and salpingo-oophorectomy. Performance of such surgery was an unauthorized invasion and interference with the patient's body, which amounts to a torturous act of assault and battery and therefore a deficiency in service. The case was decided in favor of the patient and awarded Rs 25,000 as compensation for unauthorized surgery and exempted the respondent, that is the doctor, from receiving any fees for the surgery. So what are the key medico-legal lessons from Samira Kohli versus Dr. Prabha Manchanda? First and foremost, patient autonomy is supreme. Consent for a diagnostic procedure cannot be stretched to justify a radical therapeutic surgery, even if the doctor believes it is beneficial. Second, proxy consent has strict limitations. Consent from a parent or relative has no legal validity unless it is life-saving emergency. Third, good intention is not a legal defense. The Supreme Court made it crystal clear removing an organ without valid consent amounts to assault and battery, not mere negligence. Subscribe to Docnur for more updates on landmark medico-legal cases and judgment analysis that shape healthcare jurisprudence in India.